morning. My name is Donna Marie Collins. I'm the hearing examiner that will be presiding over this morning's zoning case. It is a conventional rezoning, which means the decision will be final with me. I see that I have the affidavit of publication for this hearing has been properly advertised in accordance with law. All testimony and evidence I accept during these hearings must be taken in under oath. Therefore, if you intend on speaking on the record, I ask that you please raise your right hand. Do you swear or affirm the testimony and evidence you place into the record will be the truth?
I do.
Okay. Thank you. Since we don't have any members of the public, I'm going to dispense with my typical welcoming presentation and say that I'm ready to begin.
All right. Good morning, Madam Hearing Examiner. I'm here today to talk about Chief Court, Rezone 2023-00029. Oh, this was working, Pete, but I think there's always something about which screen you're on.
There you go. Try to.
There it is. Yep.
Okay, good. We got it to go. Do you have a paper copy of your PowerPoint for me?
I do. Yes, that's the first thing to take care of. So I have three things, and you could, because I don't think they were in. So yes, first exhibit would be paper copy of the PowerPoint.
Thank you, Fred. That's applicant exhibit 1.
And I have two other things, and you can tell me if you want them. One is the email chain about the violations with John Guzman from staff. The other one is the amended agreements on the violations that the zoning is taking care of one of the violations, and then the others can fold it. So we have a slide on it just to itemize the.
Sure, I'll take it because of background, just
Yeah.
as background information.
Right. That's what I was thinking too.
But I assume once the zoning is approved, that will take care of at least a portion of one of the violations. And then with regard to open storage, there's going to be a responsibility to screen the property in accordance with
Yeah,
the
there's
code.
to fix the other one, there's a development order. The zoning allows the development order to be approved, and the development
Okay.
order's underway, and it's what Bob Case is here from engineering. He's doing the development order.
Okay, and it's contingent right now on the zoning
Yes.
going forward?
Yeah.
Okay, I'll take those documents.
Okay.
Thank you. Thank you, Fred. All right, I'm ready.
All right. So I'm here today with Donnie Carter, who him and his father Don Carter, operate the offshore performance specialties business that's in this industrial court, and so he's here to answer any possible operational questions or future plans. But also with me is Bob Case from LIS Engineering, who is taking care of the development order, and engineering has been working with them for quite some time, even before they brought me on board to help with the violation of the zoning for the open storage on a small section of the property. I would like to say that, or be offered into expert as planning and land use in the land development code. I've been accepted in here in this forum before, and like to be accepted in that realm today.
Yes.
And
Please proceed.
I think Bob Case as well for civil engineering.
Yes,
and
he's been
drainage.
testifying here for
I think,
longer than we care to say.
yes, yeah, a few years, yes.
But who's counting?
So the request is for a conventional zoning of 1.88 acres from AG2 to general commercial. I'll show how that's broken down because it's a little bit odd. One of the parcels is a kind of a half zoning parcel, and we'll go through why. The property is located in the this Briarwood Industrial Subdivision. It abuts 10 Mile Canal to the east. There's Michael G. Rip Parkway, the metro extension, just south of Briarcliff Road to the east. It connects through to US 41, South Tamiami Trail on Young Chris Road, which turns left onto Chief Court. Has Madam Hearing Examiner been to the site?
I have not yet. That's what I'm going to do as soon as we're done with this hearing.
So you just see the character of the area. It's almost a built-out subdivision. a lot of good local Lee County businesses been operating there for a long time in similar capacities to what offshore does, which is really boat repair, engine repair. I mean, I don't even know the full extent of everything they do, but it's a thriving business taking care of all the boats and a lot of the boats in Lee County.
It's sale and service, right? Sale and service.
Sale and service, yeah. Well, I don't know if they sell boats. No, it's just, but sales of parts and performance parts to upgrade boats and,
Or refit boats.
yeah.
Okay,
So no sales of actual new boats or used boats,
just parts.
performance
needed for
parts, and then they
repair.
upgrade them and repair them. And then, of course, they have a lot on site, so they need a place to put them, which is part of why we're here today. You know, as
All right, so they're performing this work on site.
yes,
So part of the violation stemmed from storing boats that are going to be worked on or have already been worked on.
yeah.
Or waiting.
Understood. So you're rezoning so that
Waiting
you
for
can-
parts,
Yes.
you know, stuff like that, yep.
This way you'll be able to use the entire site for the business.
Yeah, which it has been used that, means some, you know, but, so that's why we're here to help fix that and make that legitimate.
That's right, we'll get them on the straight and narrow.
Yeah, that's right. So here's the current development. This is the performance, so both these buildings are part of their operations. One's offshore marine and then offshore performance specs. So
So what's the difference between the two? They're two separate businesses? They do two separate things? What's happening on the site?
yeah, this, I mean, I'd love to hear Donnie say that best because he knows this whole operations better than I do.
Okay,
I mean, honestly, Offshore Performance was our main company. That's what I run. Offshore Marine Center was a company my dad had. He would fix up boats and do special projects, kind of stuff he enjoyed to do. Unfortunately, he had a stroke back in November, so that part of the operation is winding down. But,
and so what does the other business do? That's yours?
well, I'm partners with my dad in it, yes. So we bring boats in, we service them, we refit them like new engines, do all the services. Like we take care of Lee County Sheriff's Department, we take care of all the county fire, and a lot of personal recreational boats.
And what was the other business that's winding down?
Offshore Marine, it's still functional. We haven't shut it down. We've finished up some of the projects my dad had, but it's still just,
But it's the same type of business, right?
yeah, he basically, exactly same type of business.
Okay.
So it's on both those properties. So when, in this one, I showed the example of, I mean, of all the properties that they now own, we're only rezoning a portion of that, and that's what I'm showing here are really the two properties where it's operating. In the back of this here is where they're storing boats where it's zoned AG2, and that's part of what we're rezoning. So this is 0.57 acres in the back of this. And then this is the area that is purchased for expansion of similar and storage, and these were all, yeah, so this is an AG2 zoned as well. So in order to do any type of outdoor storage or anything like that on
So is
those,
the violation limited to the half-acre parcel?
it is,
Yeah,
yeah.
okay.
Yeah, because this is okay. I mean, there's,
That's just vacant right now?
It's just vacant.
Not used yet?
yep. So this gives you the overall picture between what they owned overall in the yellow, and then the two that are AG2 that they're already using that they wish to put on the straight and narrow, and then the new one that they could expand into. We're zoned it to commercial general. We don't need to do boat repair on those properties. They just need the space to store these boats as they come in and are waiting for parts and the other things that we're talking about. So we didn't need to do IL zoning on them. And we're here doing the commercial general. It's really the highest and best use you can do in the urban community future land use category without being required to go to an industrial plan development, which we thought was just, we didn't need it. And IPD would have been useful if we want to expand the actual repair on those sites and build facilities where we're actually repairing the boat engines, but we really just need a storage area for boats that are already
So you
there.
couldn't do IL? You couldn't have just rezoned to IL?
We could not. Yeah, comp plan
Had to be planned development.
would have required it to be a planned development when it's not an industrial future land use
Okay,
category.
so if in the future the business expands to the point where you would need to use that area for actual boat repair, then you'd bring the whole property in for PD, I would imagine.
Yeah, that's what we'd have to do.
Okay.
Yep. So they're going to be limited to that for just the storage use only. I mean, other uses in CG, but that's what they're going to intend to do.
So I wasn't aware that they also own the parcel. I thought it was only that parcel. not-
Yeah, that's the offshore marine, and then there's the offshore performance. Those are the
Alright,
two buildings.
my maps don't show that other. That's no matter, okay.
Yeah, probably not, because it's, wasn't part of the case, yeah.
Okay, thank you.
So same thing here, future land use category. So the property abutting, so you can, this one gives a good view of why historically this is an odd zoning. This was the Seaboard Coastline Railroad. That was at one point right away for the railroad. So over the years, some of those have been rezoned correctly, but they've been or the lots have been merged, but some of them haven't. And over the years, I mean, that one sat owned by Seaboard for a long time until Don Carter bought it. But that's why the zoning is there, and you can see the trail all the way up. So this is really fixing just historical stuff that Seaboard doesn't need it for anymore. But even on the property appraiser, it still lists as railroad right away, but owned by Don Carter. And future land use, like I said, urban community, and that caused us to go in order to be conventionally zoned, and knowing we didn't need the use that would allow us, that would be needed for an IPD. That's why we're here. So this is to show, this is the northern parcel that hasn't been used yet. This is the offshore marine, and offshore performance is just to the south. This is just showing the Briarwood subdivision, a little bit of a closer look, and where there's similar uses that are industrial in nature, or warehouse in nature. And really the important thing is to show where the closest residential parcels are. This is the Laurel Oaks Unit 1 subdivision plat. It was done in 1992. The Briarwood Industrial Subdivision plat was done in 1986. So it does look like the Laurel Oaks was platted after the industrial park, so there was knowledge of it. Looks like maybe part of this setback behind these buildings was maybe established for that. I'm not sure, but because it's all conventionally zoned IL as well. But it seems that these were built with the full knowledge that there was an industrial park to the south, or at least going to be. And with the storage, of course, if there's the storage of boats on this, will be required to meet all the land development code requirements for screening and setbacks and everything on that corner towards the residential area. The infrastructure, so other than sewer, all urban services are in place and currently serving the property. So the property is enforced utilities franchise area for sanitary sewer service. They have not extended the lines back to this area. They don't necessarily have a plan to do that, but it is in the franchise area. They've been operating on septic. They will continue to operate on septic like the rest of the subdivision, and then subject to state statutes for total volumes. It's with this addition, it'll just be more storage area. It's not necessarily expanded to a level where we anticipate will be required to connect to sewer. And obviously the property is much more than a quarter mile away from the closest possible utility connection at this point. So we're not being forced or asked to extend to connect to any sewer service areas. If they ever put the lines back there and they run them back there, then great, we'll connect. But as of now, we're not required to. And so we'll continue to operate under septic. Other than that, all the other services are in the area and in place. So you can just have Bob walk through the violations real quick, just to give you an overview of what we're trying to fix. The rezoning is to abate the code violation case 2023-4469. That was because of permitted uses, so the use of AG2 zone portion of property for the open storage of multiple vessels and other materials equipment is not permitted. So that's what we're here to fix with the CG zoning. So if you want to do any detail here.
Morning. For the record, my name is Bob Case. Appears to be a total of 5 violations. First violation, VIO 2023-044866 and VIO 2023-04469. Permitted uses violation, AG2 property being addressed, zoning action in progress, should have a hearing by 2024. There's total of 5. So they violated the one in the corner, on the southeast corner, for the storage of the boats. Let me go through all of them. There was an agreement also between the county and the owner, an enforcement agreement on that pending the issuance of the zoning and the development order that's going to be required for the storage facility. The violations, let's see here. And they kind of go through the agreements here. First one, and my eyes are not as good as they used to be. They kind of, the permit, large freestanding structure, construction without a permit. That is a tent structure on the east side of the south parcel. We would fully intend to remove that tent and to replace it with a permanent canopy. That would be the first violation.
With permits.
It would be a building permit and it would be included in the development order. Obviously, you can't get the building permit without the development order. That tent structure, and I don't know if you want to go back to that.
Won't show on that one, but it will show on that one.
Top right. Top right.
Right up here? Yeah, there it is.
Yes, there it is, right there. That tent structure. So we're going to, that was constructed without a permit. A lot of activity after the hurricane. A lot of damaged boats. All the maintenance is typically done within the structures themselves. They added that on. That's going to have to be removed and replaced with a permanent structure and be addressed in the development order and with the building permit. Okay, second one. And that's also part of the settlement agreement too. Work without a development order. This one is VIO 2023-04466. Work without a development order. The open storage of vessels, storage, containers, materials, equipment, and miscellaneous items along the parking lot and on the AG2 zone parcel. So that would be the violation for the one in the corner. Third violation, VIO 2023-04469, permitted uses in accordance with Lee County Development Code 34-0522, 655 and 654, the use of AG2 zone portion of the property for open storage of multiple vessels and other materials and equipment is not permitted. So it's kind of like
Duplication.
piling on, yeah. Fourth violation, VIO 2023-04471. Work without a development order. The open storage of multiple vessels, equipment, and machinery is not permitted in accordance with current development order 94-01004-000. In other words, that was not in the original.
So it's beyond the scope of the original development.
Exactly. Once again, same,
Okay, so just to understand
Yep.
the path to abatement, because these details are really not relevant to what I consider for the criteria
Yes, ma'am.
to zone. My understanding is, in order to abate these violations, the property needs to be rezoned, the existing development order may or may not need to be amended, and a new development order will be issued on the parcel that will be zoned CG.
That is correct.
Is that correct?
Actually, it would be a separate development order for the ag piece.
Right.
The only, which would be this parcel, of course, the 1.31 acres. The existing development order may accommodate the tent structure. Through the, you may have to do some sort of minor LDO.
You're going to need a DO on this half.
You need a full DO on the storage area for sure.
Okay.
And that would include the landscaping, security fencing.
All right, so this is
Stormwater
really the
management.
first in multiple steps necessary.
That is correct. That is correct. We couldn't apply for the development order because it didn't have the underlying zoning correct. And
All
so,
right, well, you're taking care of that part today, so.
absolutely, absolutely. More to come, for sure. And then I think the final one was VAO 2023-04572, not in compliance with development order, missing landscaping, clearing vegetation without a permit. So I'm going to have to get back into the original one, restore the landscaping on the existing area. And at that point, when I do that, I'm going to apply for the LDO to do the tent building.
Okay.
Replace it with a permanent structure. I think there was, one more. VIO 2023-04573, not in compliance with development order. So,
Right.
as Fred said, I don't anticipate any utilities. It could be a possibility the fire department would want a fire hydrant out by the storage area, which I think is highly likely, so we might have to extend the water main out there.
So the property is serviced by potable water
Serviced by potable water and sanitary septic,
and on-site septic.
and on-site septic, yeah.
Okay.
But they may require that for fire protection, for the storage
Yes.
area, which I think is pretty likely.
All right, I can finish up here relatively quick. So there's the land development code and comp plan consistency that's important. But I will say we are in full agreement here with the staff report. Mr. Blackwell's analysis was, we think, is accurate. He finds us consistent with the section 34-145. We agree with his analysis. We believe we are consistent as well. Same with the policies, with the future land use category and the different objectives. Policy 5.1.5 for abutting the neighborhood or the residential commercials, residential structures in the subdivision to the north. So again, we'll rely on the staff report and their analysis, and our analysis is in your packet as well. And we will stand with that without having to go back through all of it. So staff recommends approval and finds us consistent with the land development code and the comp plan, and we believe we are consistent as well, and we ask for approval.
Thank you.
Thanks.
Peter?
Good morning. For the record, Pete Blackwell with the Lee County Zoning Section. REZ 2023-00029 is the proposed rezoning for the Chief Court industrial parcels. Staff finds that the applicant's presentation was accurate and pretty comprehensive, and so I will just instead of the overview, I will just go straight to the criteria for approval. First is the compliance with the LEED plan. The proposed rezoning category, general commercial, is compatible with the urban community future land use category. Because the location is in an already developed area and is really an expansion and infill, we find it perfectly acceptable in terms of objectives 2.1, 2.2 about premature development and timing. The utilities are available, so objective 4.1 is satisfied. It's not considered an encroachment of an inappropriate use. As stated, it's part of an existing industrial park, and there's really only one point where it touches the residential community to the north. It's just a corner touch. And this does represent well-planned commercial development per Goal 6. As far as the compliance with the Land Development Code and other regulations, they're following the proper procedure for the REZ. They've outlined how they're going to meet the violations, and the CG zoning will allow them to meet those violations. Any future activity will be required to go through the Lee County regulations or seek a variance therefrom. So at no point are they deviating from the proper procedures. For the compatibility with the surrounding area, again, they're very much an infill development because they're mainly within the industrial area between US 41 and 10 Mile Canal. On their east, they're very well buffered by a canal, a railroad, a major roadway. They're buffered from the Laurel Oaks subdivision, mainly by the other parts of the Briarwood Industrial Park. And as far as their storage uses, they must conform to LDC 34-3005, which is the visual screening requirement for their open storage areas. And the only part that's visible would be a small corner from Laurel Oaks, and that would require the 8-foot fence rather than the 6-foot fence required for the other parts. So there's no issues with compatibility. They do have sufficient access via Chief Court to Youngquist Road down to US 41, very short distance. It's all paved and well serviced. The northern strap, which is the vacant one, it unto itself does not have access, but it is part of the commonly owned area which has the access. So if they need to, they can get that access in there.
These parcels are not in the industrial subdivision. The industrial subdivision goes to the limits of what was once the Seaboard Railroad right-of-way. But they're abutting and they will achieve access to Chief Court via the main parcel that is part of that subdivision.
Exactly. There's currently no traffic impact study required, and when they go for their DO, that's when they'll be required to provide that. As far as the environmental impact, no protected species or native vegetation were found by environmental staff, and there were no issues. They will need to, of course, come into compliance with any environmental requirements such as buffering and others, which is, of course, being done through the violation process. For their urban services, they have the potable water. They can, if they need to, get access to forest utilities for sewer system, but they do not currently require it. The fire and EMS are only 5,000 feet away. There's a lead tran route right there on 41. And therefore, based on these criteria, staff finds that the proposed rezoning from agricultural AG2 to general commercial is appropriate and recommends approval of the request to rezone from AG2 to CG.
Thank you.
All right.
I don't have any questions. I feel well prepared for this case. The only thing I need to do really is the site visit, which I will be doing later this morning. You're very fortunate because I'm caught up with my cases, so as soon as I do my site visit, I can turn my attention to this case and hopefully issue a final decision shortly.
Nice. Great.
Thank you.
Thank you.